Okay. Welcome, everyone, to today's LexisNexis Canada featured webinar on navigating AI and privacy law in Canada. I'm Matt Canning, in-house corporate counsel for LexisNexis North America and the moderator for the panel. As most of you are probably aware, AI and privacy are reshaping how organizations, governments, and individuals interact with technology and personal data. We're excited to have you here as we unpack one of the most dynamic legal landscapes in the country. With the adoption of AI technologies and platforms accelerating and privacy expectations rising, legal professionals are being asked to lead through a framework of uncertainty, and we're here to help you with that. So today we'll explore how Canada's fragmented regulatory environment as it relates to AI is impacting and shaping compliance, innovation, and risk. From the pause of Bill C-27 to the enactment of Quebec's Law 25, we'll do our best to help you make sense of what's enforceable now, what's coming next, and provide practical and strategic suggestions for moving forward. Throughout the webinar, there'll be poll surveys. It would be much appreciated if you could answer these for our business folks. If you have a question for the panelists as we move through the topics, please write them in the chat below, and we'll do our best to address them towards the end of the webinar. So without further ado, we're joined today by two outstanding experts in the AI space. Our first panelist is Danielle Miller Olofsson. Danielle is an author and associate at Stikeman Elliott and a leading voice on privacy law and digital governance with extensive expertise advising clients on compliance and regulatory strategy. Our second panelist is Timothy Banks. Tim is an author and technology lawyer at nNovation and a recognized authority on AI ethics and legal risk. Tim's work bridges the gap between emerging technologies and responsible legal frameworks. Danielle and Tim, thank you both for being here.
Thanks.
Thank you.
So let's jump right in. Beginning with the big picture, Bill C-27, which includes the Consumer Privacy Protection Act and the Artificial Intelligence and Data Act, was not passed due to the prorogation of Parliament in 2024. But many organizations are still using it as a benchmark for privacy and AI readiness in anticipation of future legislation. As we understand it, Bill C-27 was supposed to be Canada's comprehensive attempt to modernizing privacy and AI regulation in Canada. But with Parliament prorogued, it's off the table, at least for now. So Tim, let's start with you regarding Bill C-27 from the perspective of AI. What gap was Bill C-27 trying to fill? Does that gap need to be filled? Let's hear your thoughts on this.
Sure, yes. So let me start by doing that level setting of where we're at federally. And at the same time, I'll answer that question about whether I think we need an AI law or laws. And spoiler alert, I think that we need AI laws, but maybe not necessarily an overarching AI law. And I also don't think that privacy laws are the place to regulate AI. I think we need to regulate sectorally and in context and to focus on harms. And we don't need to regulate everything in order to regulate something. So I'll get to all of that, but stepping back right now, we don't have, obviously, a federal law that's comprehensive that regulates AI across the country and in all sectors. Bill C-27, and in particular AIDA, the Artificial Intelligence Data Act, was going to be an attempt to fill that gap. But as you said, it died when Parliament was dissolved for the election. Now, I think it's going to come back in some form. And so we should talk about how those laws were going to work. Now, as I mentioned, there might be a difference of opinion on the panel about whether we need AI laws. And so, but we may disagree about whether or not privacy law is a proper place to regulate AI. So I'm not so sure that privacy laws, as I mentioned, should be used to try to fill this gap. So because I think they're really, what we're trying to do is regulate different things. Take PIPEDA, for example. So PIPEDA is the Personal Information Protection and Electronic Documents Act. It's our federal legislation, still in force. hasn't been repealed because Bill C-27 did not go forward. It's designed to protect personal information, and it does that by focusing on control over data. It asks, did you get meaningful consent? Was the collection for a proper purpose? Is the data accurate? Is it secure? Is it limited to what is necessary? And these are important safeguards, and they aim to protect people. But the emphasis is on individual control, and it treats personal data as something of value in and of itself. But when it comes to artificial intelligence, we're really focused on the technology and the harms, the potential harms from the technology. And so the focus really is on outcomes and the process getting to that outcome. Who gets hired or denied a loan? Who's profiled, flagged, excluded? Can we explain decisions that are made about people? Can we challenge them if something goes wrong? PIPEDA could be used to try to touch on some of these issues through the appropriate purposes test or accuracy requirements, but it was not built to handle the full picture of AI downstream effects, particularly those effects that are group-based or structural. There's another issue that is not addressed in PIPEDA, and I don't think it could only very awkwardly be addressed. And that's an accountability framework for how the AI is designed, tested, and deployed, and particularly for systems that carry higher risk. And that's what AIDA was trying to do. It would have introduced risk-based classification, mandatory impact assessments, and ongoing monitoring and incident reporting. But AIDA was far from perfect. Too much was left to regulation, and too much was handed off to government discretion. Things like what counts as high impact, what needs to be disclosed, and even what are the enforcement powers that regulators are going to get. And AIDA didn't answer those questions fully. So let me just level set by, I'll throw up two slides. We're going to start with the CPPA slide. And just to give you an overview of, well, although the CPPA, the Consumer Privacy Protection Act, was the privacy side of Bill C-27 and not an AI law in itself, it still matters for AI. It extended some important rights. So, for example, if automated decision making affected you, you could ask for how it was made and what data it relied on. If AI is in use, they have to tell you in simple and plain language terms. Where consent is required, organizations need to explain the real world consequences and not just technical details. And so this is privacy law doing what privacy law does best, right? Focusing on transparency and control. So those were the relevant obligations under the CPPA. Moving to the next slide, the AIDA slide. AIDA, of course, is taking a different tact. It's, while CPPA is governing how data is collected and used, AIDA is focusing on what the system does and how it was developed. So it was aimed at high impact systems, those that affect rights, opportunities, or safety. And it would have required, although it wasn't fully defined, we'd have to wait to the regulations to figure out what was exactly in. And that's part of the problem with AIDA. But it would have required companies to identify and mitigate risks, explain how their systems work, report when things go wrong, and avoid reckless deployment. And so it takes a different shift, and instead of regulating AI just as a product, it's regulating the whole process or life cycle of AI, how it's built, trained, monitored, and improved over time. So why am I concerned about having a dedicated AI law? In Canada, there's a strong tilt towards the precautionary principle when we regulate. In the privacy context, organizations are required to implement safeguards to protect privacy. And although they're supposed to be proportionate to the harm, really, organizations are held to the privacy principles even in the absence of real demonstrable harm. And if you don't believe me, I can cite many, many examples where privacy commissioners come to decisions in Canada, require organizations to change their practices, and the word harm never appears. There's no demonstrable evidence of any harm to any particular individual. but somehow the issue, somehow the organization is still violating privacy laws because the law isn't really about the harm necessarily. It's about protecting privacy and control over personal information as a good or right or value in and of itself. So we apply the precautionary principle, we avoid risk, we slow things down, we prioritize rights, even if it comes at the cost of innovation. And sometimes the tilt goes too far. In the Trang case before the Supreme Court of Canada, the court found that lower courts had tilted the balance too far, that they were prioritizing privacy over business needs. But this message doesn't make its way all the time to regulators. Just last year at a conference that I attended, a privacy commissioner here in Canada said that he would always favor privacy rights over business needs. And that kind of ignores the statute that governs his decision-making, which requires him to reconcile privacy rights with business needs. But that's the mindset of the precautionary principle, always prioritize the right over anything else. So my concern with AI is that that same precautionary principle will creep in when we're trying to regulate an entire industry instead of focusing on harms sectorally. And so I already see that precautionary principle in Canada, not just with regulators, but it also creeps in to my own clients, right? We see a lot of hypothetical fears of AI rather than real harms. How many of you have contracts that state the vendor may never use your organization's data in AI? The vendor can never apply AI to your data. But I ask my clients this question. So does that mean that you're saying your vendor can't use Copilot in order to redraft the email to you, in order to make it grammatical, clear, concise, understandable, jargon-free? Is that really what you care about? Or do you really care if they use a bot to manage timesheets so that they can give you a more accurate bill, more timely, more well-organized, with consistent uh, uh, wording and meets your particular bill format requirements? Is that what you're worried about? Is that the harm you need to regulate? And so we see in Canada, I think, too often a rush to worry about the ghosts under the bed and in the closets, instead of kind of articulating what the particular harm is that we need to regulate. And so as a result, I'm very worried about leaving it up to governments and regulators to define in a broad way what harms there are, because I think there'll be this inclination to try to regulate everything instead of regulating the specific harms that we start to see occur, because they'll want to get out in front of it. So that's sort of a level set of where we're at are in terms of the CPPA and AIDA, if they come back, some of the problems that I see there. And then in answer to your question, Matt, yes, there is a gap, needs to be filled, but maybe not by one comprehensive law.
Thank you, Tim. If everyone could just take a moment to answer the poll, that would be great. In the meantime, while Bill C-27 sits, Quebec has surged ahead. Law 25 is now fully enforced and arguably the most stringent privacy law in Canada. It introduces new rules for both public and private organizations that handle personal data. It grants individuals enhanced privacy rights, and it imposes new obligations on businesses. Not to mention non-compliance penalties can also be significant, ranging from up to 25 million or 4% of global revenue. So going to you, Danielle, since Law 25 has been enforced for a while now, what can you tell us about its impact with respect to AI from your perspective? What gap is Law 25 trying to fill, and does it need to be filled?
Thanks, Matt. I'd like to echo what Tim was saying with respect to artificial intelligence and legislation concerning artificial intelligence. I actually think it's premature to be speaking of regulating artificial intelligence at this point in time because I don't think that we really know what we are regulating. I think we're at very early stages technologically with respect to artificial intelligence. I think if we look at the legislation that exists, for example, the European AI Act, what that is essentially a codification of best practices around things like transparency and risk assessment. And I think that AIDA, one of its problems was very much that. It was sort of a wish list. There wasn't much concrete about it. And I think we also have to note that even within Europe, there are countries that are opposed to the implementation of the AI Act because they believe, and I share that belief, that there is a potential to hinder research, development, innovation. I also, and to Tim's point, I'm not clear on what harms are specific to artificial intelligence that aren't already covered by existing legislation, such as the criminal code or IP legislation or data protection legislation or charters of rights. And finally, and I think also this gets to the crux of the matter, is that if we are going to regulate and legislate in this area, it should really be done at a provincial level using the property and civil rights power of the provincial governments rather than the trade and commerce power, which was how PIPEDA has been justified, and it was also what was going to be used to justify the artificial intelligence legislation. And what I want to say here is one of the, I think, challenges with PIPEDA has always been that it cannot really regulate in the sphere of employee personal information. And if you're an organization, that is a substantial amount of the information that you're processing is employee information. And to have a law that doesn't even address that is unfortunate, for lack of a better word. And so then with that backdrop, I would say that Law 25, the law that I guess purported to overhaul private and public sector data protection legislation in Quebec, along with several other laws, is an example to follow, I think, if we're going to go along this path. To begin with, I think it makes sense constitutionally. It's legislation that's using, Section 9213, the property and civil rights jurisdiction, which means its scope, I think, is more effective. Unlike AI, it's very clear what we're getting at here. We're regulating the use of personal information. Personal information is clearly defined in this law, as it is in PIPEDA. Organizations that collect, use, disclose, store, otherwise process personal information have very clear duties that are incumbent upon them in order to comply with this law. And data subjects are given very clear rights. So, we have the right to access, to amend. Quebec has introduced in certain circumstances other rights that we don't see in other provinces yet, such as a data mobility right or a right to request that one's personal information be de-indexed. So I think that with Law 25, we really know what it is that we're regulating. We're regulating personal information. The last piece that I like about Law 25 is it comes with teeth. It comes with severe penalties and fines for non-compliance. And so to me, it's a law that is coherent within Quebec's, legal landscape. And so it'll probably be easier to enforce and to adhere to.
Thanks, Danielle. So in other words, you would view Law 25 as perfect?
No, I would not view Law 25 as perfect. I think Law 25, like everyone, has its shortcomings. Several shortcomings that I would note are, first of all, it's a law that is heavily inspired by the European GDPR, but unfortunately, it isn't built upon the same conceptual structure that the GDPR is. And what I mean by that is the GDPR draws clear distinctions between what it considers a data controller, which is the entity responsible for collecting data, identifying the data, well, not necessarily collecting, for identifying what data will be processed and how that data will be processed, and the other entity, which is a data processor, and that data processor must act on instruction of the data controller in processing personal information. And so one's duties and obligations are very much a product of whether you are a data controller or a data processor, and they're not the same responsibilities. In Quebec, we don't have that distinction, and so hypothetically, a data processor operating in Quebec could be held to a higher standard than even in Europe. So that's kind of ironic. The second thing that I find challenging with this, with Law 25, is I find that it imposes sometimes unrealistic standards on the entities it's regulating with respect to certain things, notably biometrics, which we'll touch upon later. And in doing so, serves to widen the gap between Quebec and other provinces when it comes to regulating in this sphere. And the third thing that I guess that I'm quite critical of is the fact that we still approach personal information and the protection of personal information as if it were a human right. So personal information is inherently private and all of it has to be protected. So instead of looking at personal information, perhaps some of it could be, yes, linked to your personal private sphere as a human right, but there is other personal information that I think we've got to start looking at as a property right. So an example would be a favorite brand of marmalade. That is personal information to me. I don't particularly care that the rest of the world knows what my favorite brand of marmalade is. However, a store, a supplier that's stocking that does care about that because they want to be able to sell it to me. They want to be able to offer it to me when I'm in the vicinity. So that information is really important to them. Why am I not allowed to monetize that information? The way things stand right now is I'm told this is personal information. It has to be protected. I can't necessarily monetize it, but a store, provided they tell me how they're going to use that information, can actually use it without for as much compensating me. It control is something that we want to give back to an individual. I'm not sure that treating personal information necessarily as a human right, as a personal right, is the right way to go about it all the time. So there, my soapbox.
Not perfect.
Not perfect, but very good start.
It's a good start, yeah. Let's talk about some real world issues here that you're seeing in your practice. So Tim, let's go back to you. Can you give us some examples of what clients are coming to you for regarding AI and privacy related issues? And sort of what does the landscape look like from your perspective?
So there seems to be new issues every day and they run the gamut, but I'll pull a couple. And one I'd like to pull out is automated decision making, because it was addressed in the CPPA in Bill C-27, and if it comes back, I think it will be addressed again. Could we go back to the slide on the CPPA if that's possible? Perfect. So as I'm sort of talking about this example, I mean, have these obligations in mind and think about how you might operationalize them within your organization, because those are the problems that my clients are facing. So the definition of automated decision making in C-27 in the CPPA was any technology that assists or replaces human judgment using rules-based systems, regression analysis, machine learning, and the definition went on. The assist part is different from Law 25 as I understand it, where the rules under Law 25, I believe, Danielle, you can confirm after, apply when it's exclusively used to make a decision, but you'll clarify that. But I want to focus on this assists human judgment and rules-based systems. Like, that's incredibly broad. It's as though the group that got together to draft the law was so worried about leaving something out that they they tried to include everything. So even a spreadsheet with formulas is a rule-based system, right? To an aggressive privacy commissioner. So if I use a Excel spreadsheet with rules and formulas built into it to score resumes, am I now under AI regulation? Should I be? Should all of these obligations that you see on screen apply to me? How would I operationalize that? So, so first of all, I think the definition of what's covered by automated decision making is overbroad, and if it stands, organizations will have a hard time operationalizing that. And then the second thing is that these rules that you see on screen apply whether or not there's an actual harm to the individual. It's only if there's an impact to the individual, then the rules all apply. But of course, not every impact is bad. And this is where Danielle and I converge, which is, well, what are we trying to regulate? Let me make a concrete example. Suppose you're a federally regulated employer, or this provision is replicated provincially, and you're a provincially regulated employer, and you're doing the resume screening that I talked about. The AI is going to screen the resumes, but a human's going to make the final hiring call. If you got the job, do you care? Is any of this meaningful to you? Now, if you didn't get the job, maybe you do care, but I'm going to do some variations on what happens if you were screened out without anyone looking at it. That might change your mind, that maybe not in all circumstances you should even have the right to care. So let's imagine that the AI, and this AI is out there right now and is being used by organizations. It's used to screen the resumes by using a large language model to look for similar terms. So let's say the job ad said, you need to have 10 years experience in operations support. In the olden days, got a stack of 100 resumes, don't have time to read through them carefully. I'm looking really just, did someone mention operations experience, operations support in their cover letter or resume? If not, I'm moving on. But the AI is actually looking to see whether the candidate may have expressed themselves in different terms, but meant the same thing. Did they write office manager, administrative services, some other cognate term? And so the AI is helping to look for other diamonds in the rough that may not have used the exact terms in the job ad, but otherwise meet the qualifications and should be considered. Well, what if the person didn't use any of those terms? Is that a negative impact because they were screened out? Is that really a harm if they either didn't have the experience or didn't complete the assignment as required? Should all of these obligations be on the organization? Maybe you'll say, oh, well, obligations aren't that onerous, we can do it. But the problem is that these AI tools are going to creep up and also be embedded in tools that you're already using. And so you're going to be spending a lot of time doing AI governance reviews for situations that have very little true negative impact on an individual. That is as the result of the AI versus just as a result of the fact that decisions have to be made about people. And so here's the kind of the larger point about the choices that we have to make. Should we let human rights laws handle discrimination, let employment standards laws handle management of employees, and let consumer protection laws handle sales and marketing tools, or are we going to have this overarching law? And I think that when you end up with too broad a definition of what constitutes an automated decision making, and then all of these obligations, irrespective of whether there's a harm to an individual, we're regulating for regulation's sake rather than for anything meaningful for the individual, and it's going to be operationally difficult. So clients are coming with those issues. How are we going to set up, if this law comes back, how would we implement the automated decision-making rules? Another issue is around agentic AI. This is coming up and creates a number of interesting issues. So an example would be let's say I developed an AI tool that looked at my Spotify list, looked at the bands that I was most interested in, scanned for concert tickets, Ticketmaster, booked without me overseeing any of this, booked a concert, accessed my credit card to pay for the concert, added the event to my calendar, sent the event to my date for the concert, sent the calendar appointment to the date of my concert, and then shared with my friends on Facebook that I'm going to the concert. If a consumer wants that, why can't they have it? But from a privacy perspective, how are we going to analyze that? That the AI agent has been collecting personal information from me, disclosing it to third parties, and using it for the purposes of probably not only providing me with this service, but for other issues as well. And what happens when something goes wrong? And does the vendor and the credit card company and others have to permit the agentic AI? So that's going to be a complicated issue in terms of allocating responsibility and liability amongst all of these parties, and also allocating responsibility even for something as simple as consent. Did Ticketmaster, in my example, have consent if the consent was given through the agentic AI rather than by the individual themselves? So those are kind of interesting issues that are coming up, as well as regulatory interoperability, but we can talk about that. We can talk about that later.
Thanks, Tim. Certainly great points on both examples. Danielle, what are you seeing on the Quebec side of things?
On the Quebec side, I actually wanted to talk about biometrics because there's this other law that is perhaps a little unloved or not as well known, which is the Act to Establish a Legal Framework for Information Technology. Now, it's a law that's been around for a while, but it was also amended with Law 20 or through Law 25. The reason I want to talk about biometrics is because it's an area where we're seeing a lot of consultation on the part of clients. They're trying to position themselves with respect to this law and the fact that frequently they've already been deployed, or their biometrics projects have already been deployed. So how do we make them comply? The other thing is I think that this area is let's see, it's at the crossroads of AI and also of personal information. And I think that it illustrates my point that the harms that we can identify at this point in time that are, I guess, linked to or caused by AI are effectively addressed already in existing legislation. So, for example, I have a shopping mall and it has cameras positioned in various places. These cameras are able to capture people's images, and thanks to an AI algorithm, transfer that or transform that information into statistics or into some form of data that is able to tell merchants who have stores within that shopping mall that a certain individual, a certain gender, a certain age group is in a certain vicinity of that shop. That shop can then send targeted advertising to this individual. So what are the issues or what are the potential harms linked to this kind of technology? Well, there's probably an overcollection. There's certainly a non-consensual collection. There may be issues with the way that the algorithm either works or is deployed. There may be discrimination. There may be a lot of issues. But what the Quebec legislature right now has said is, okay, Articles 44 and 45 of this Act to Establish the Legal Framework for Information Technology have been tweaked to basically say, Article 44, if you're collecting biometric information to identify or authenticate an individual, that individual must consent to it, must be given an alternate form of identifying or authenticating themselves, and the use of this biometric technique has to be disclosed to the Quebec Data Protection Authority. Article 45 says that if you are going to create a data bank of biometric information, this must be disclosed 60 days prior to deploying the project to the Quebec Data Protection Authority. And the Data Protection Authority then has the right to comment on the project, suspend the project, change the project if it believes that the project does not adequately protect individual personal information or privacy rights. And what's quite interesting about the way that this is operationalized, I guess, from the regulator's point of view, is it's essentially getting businesses that are using AI, but in the context of biometrics, to comply with the same processes that they would have to if they were subject to, or similar processes, if they were subject to the European Artificial Intelligence Act. So you have to disclose the use of this technology. You have to do a risk assessment because the notices to the Quebec Data Protection Authority are very much a risk assessment that they're asking you to perform and submit. And it's based on registration. And then the commission has the right to comment and to suspend if they believe that the biometrics or the artificial intelligence behind the biometrics being used in a way that will cause harm. So to me, the the potential damage that could be caused in this particular scenario is covered. It's covered by existing legislation and tweaks that were made to existing legislation. The challenge, I would say, with biometrics is that it is really setting Quebec apart from the other provinces with respect to compliance in this area.
Thanks, Danielle. And I know there's been some reference to global AI regulation and European standards. What can you tell us about adequacy status as it relates to this context?
Well, adequacy status, it is really interesting, actually, because we forget sometimes the ins and outs of this. But adequacy status is a status that is granted by the European Union to countries that the Union believes have an infrastructure and legislation that is comparable to the European Union's. And why this is important is because the way that the European legislation, the GDPR, works with respect to personal information is that organizations or entities that are transferring personal information from Europe to another jurisdiction must secure that information in either by using sort of very heavy standard contractual clauses or binding corporate rules or complying with a number of other regulatory requirements. Now, an entity does not have to do that if it is transferring data from a European nation to a jurisdiction that has been declared to be adequate. The challenge in Canada is, and what we often forget, is that only entities that are subject to PIPEDA, the federal legislation, are in fact benefiting from this adequacy status. So if you are transferring personal information to an organization in Quebec, in British Columbia, or Alberta in the private sector, you are not covered by this adequacy status. If you are transferring to a public sector organization, you are not covered. And you're probably not covered also if you're transferring health information, because these are all laws that are not, these are all laws that are exempt from PIPEDA. So it's really only within that narrow framework of PIPEDA regulated entities where that adequacy status is beneficial to Europeans. So it's really complicated when you're transferring data from Europe to Canada.
Right. Thanks, Danielle. So this is a lot of information we've thrown at all of the listeners. Great point, certainly, but I think it would be helpful if we chatted a little bit about some practical strategies or takeaways for all of the folks listening. So I'll just say that with no unified federal law and varying provincial standards, legal advisors are guiding clients through a patchwork of obligations. and at the same time trying to anticipate future reforms in the law. So the question really is, how do we move forward in this environment? Tim, what do you think?
Yeah, so I agree. So one of the issues is this regulatory interoperability and global patchwork. But the good news is that although different countries are you coming at it or in different levels of jurisdiction, different levels within jurisdictions are coming at it maybe from slightly different perspectives. They kind of converge on similar goals, right? Which is more transparency, avoid significant harm, give individual control from a privacy perspective, and have very clear accountability mechanisms. And so that gives us an opportunity to design uh, uh, design a essentially framework neutral governance process within our organizations. And I would say that probably there are three practical steps that I would start with. Um, One would be really to build an AI risk tolerance rubric. And I was just chatting with some of the people in the chat, and this kind of goes to this point, which is, start by defining what kinds of AI your organization is comfortable with and what crosses the line. So you want to classify AI systems based on their risk level. And importantly, you want to recognize the difference between public AI and private AI models, right? AI models like a public version of a ChatGPT, where your data might be ingested and used to train the AI versus a private model, let's say a ChatGPT or a Copilot or something else that's operating just inside of your Microsoft environment. And that is not, it's maybe being tuned, right, by looking at the context of your documents, but is not being trained for public use. Those are very different models and carry very different risks. Build the AI risk tolerance rubric so that you're going to require impact assessments for the higher risk ones and make sure that you have some clear internal accountability. And this is really not just about compliance, it's about making repeatable, defensible decisions and avoiding that knee-jerk precautionary principle that everything should be prohibited unless it's permitted. It's really, trying to look at, okay, well, what are the actual harms we're trying to prevent? And steering ourselves to AI tools that avoid those harms altogether or at least minimize them. Another thing that I think any organization can do right now is try to get their hands around like what's the AI use that's going on right now? Like what AI tools are being used and being used with knowledge and permission of the company? And really like how often are you getting like pings on your network? Like how often are people navigating to public AI tools and using them in their work without approval? What AI tools are being used with permission and without permission? What are they being used for? And where are they touching situations that are high risk, right? Um, and let's examine whether they're appropriate tools for those high risk environments. And then finally, I think everyone needs to go back and look at their contracts and their privacy notices from the contracts perspective, especially their vendor contracts. I think figure out are your contracts silent on AI? If they're not silent on AI, have you struck the right balance between the types of tools you're allowing your vendor to use because they're going to use them, and the types of tools that are prohibited from being used without your express permission and analysis of the risk. And then from the privacy perspective, I think you're probably using AI in connection with personal information directly or indirectly through your vendors in ways that are not currently disclosed in your privacy notices. And if you're one of the people, like some of the people in the chat, that think that's very important to disclose, well, better get on that. Let's figure out how we're going to disclose it and what it means when we disclose it. Are we giving rights even in the absence of laws, or are we or are we not? Are we waiting for the laws to require us to give rights? So those places where I would start.
Thanks, Tim. Danielle, over to you. How do you see us moving forward?
I like, well, two things. From a lawmaker's perspective, I think it'd be a good idea just to as we've been saying all along, to just sort of step back a bit. What is it that you're trying to do here? What are the harms? Regulation for the sake of regulation, I don't think is helpful. And also both data protection and AI are moving so quickly that harms that we may have been trying to address 20 years ago are not necessarily the harms that we need to address today or 5 years from now, 6 months from now. The whole idea that we can give the individuals control over their information, I don't know if that's realistic anymore. I don't know if it ever was, but I think we really do, from a lawmaker's perspective, have to sort of stop and say, okay, what is it that we're doing, and what makes sense, and how do we do it in a way that balances all of the various interests? As Tim was saying, one of the fundamental principles of PIPEDA is that it should be interpreted to, balance the rights of the individual with legitimate rights of a business. So I think that's one thing. That's from a lawmaker's perspective. From just a practical perspective, when clients approach me and say, well, look, we're doing business in Canada, what do you suggest? If you're doing business in Quebec and in other provinces, I absolutely suggest that you try at least to comply with what Quebec is asking in terms of notices and various processes, the operational measures that should be taken. These are not unusual. I mean, any business that works in Europe or California, these are not new. So clients I don't find them particularly resistant to this, but I do say that within Canada, it's probably a good idea to comply with Quebec, and that way you will be more or less compliant, pretty much compliant with the other provinces. And to Tim's point, look, the data principles that we're all dealing with, irrespective of the jurisdiction, are the same. It's just a question of how we leverage them and how we implement them. So it's not a heavy lift if you're compliant in one jurisdiction to get compliant in another. So that's what I'm advising.
Great, Danielle. Thank you. So it looks like we have about 12 or 13 minutes left. Why don't we spend a few minutes taking a look at some of the questions in the chat? I noticed there were quite a few coming in. So just one moment and I'll pose a couple of questions.
Yeah, and bring on more, right? We've got time.
Here's a good one. Danielle, this is probably geared towards you. What is the jurisdictional reach of Law 25? Can a person not resident in Quebec but doing business with a Quebec company be subject to enforcement?
What the law states is that an organization collecting information in Quebec has to comply with Law 25. So not a clear-cut answer to that, but I would say that if you are collecting information on Quebec residents, other than accidentally, I think you would be well served to comply with Quebec legislation.
Thank you.
It's sort of like other consumer protection laws.
Yeah.
The fact that you're doing business in a jurisdiction, you need to comply with the consumer protection laws in that jurisdiction.
And more of it is online too. So, in Quebec, if you are targeting Quebec residents, you've got to have a French web page. You've got to have compliant documentation.
Okay, looking to the chat. Here's an interesting one that both of you might be able to address. How do you future-proof legislation in a quickly evolving technical field? If we narrow the definitions around what the technology does, it may result in the legislation being too narrow to be effective.
Yeah. I think that's the problem with trying to to regulate technology versus regulate outcomes. And so if what we're concerned about is, for example, discriminatory impacts of technology, well, that's already regulated in human rights codes across the country. And so it's just a matter of applying existing law to prevent that outcome. If there's another type of outcome that we're worried about, then regulate that. Prohibit that outcome or that use. And you don't have to worry about your whether you got the definition of automated decision making correct or not. You don't have to worry about whether or not the technology is evolving fast. Because what you're saying is, I'm drawing a line. These types of societal impacts are wrong. We agree. We've made a decision together to agree through our political process that they're wrong, and we're going to prohibit that. How you get to that is your business, but if you get to that, we're telling you you need to stop.
I agree. I think sometimes we tend to be really arrogant as lawmakers and lawyers, thinking that law is really the solution to everything, whereas if you look at the National Institute for Standards and Technologies, their rules or regulations or whatever it is, guidelines around the development of artificial intelligence is essentially doing exactly what, the AI Act or the other sort of purported AI legislation is doing. It's regulating it based on risk assessment, transparency, uh, causing least possible harm. I don't really see what law per se has to add to the technological aspect of this. I couldn't agree more with Tim with respect to outcomes. I think that is really what we should be focusing on. And to me, at this particular point in time, I do not see an outcome that isn't covered by other legislation.
Danielle, there's another question in the chat, and it's asking to give a little bit more information on adequacy recognition for privacy laws. Are you able to expand on that a little bit?
Well, I'm not quite sure. I'd love to, but what what exactly do we want to know about adequacy decision or adequacy status?
Yeah, it's not clear from the question. I wasn't sure if you had anything else you'd be able to expand on that. Okay, let me have a look here. There's a more general question in the chat about bias. So I'll read the question, and you let me know what you think. If AI systems like ChatGPT are trained on actual data from the real world, how can their outputs still be considered biased or discriminatory? And it looks like there's an explanation after this. And it says it seems like reliance on AI would do more to avoid bias and discrimination than leaving the decision to a real person who has emotions and personal experience.
Can I give my 2 cents? And I'm sure
Please.
Tim and I, without being presumptuous, I think Tim and I probably would agree on this, that the problem is that the information in the real world isn't unbiased. And I think that's the problem, is that we call it artificial intelligence. It's not particularly intelligent. It's a sausage maker. It's, your sausage depends on the meat that you put into that sausage. And unfortunately, that meat is biased. And so, and this is what I think is challenging with the particular bias side, weeding out biases, is that you spend an awful lot of time trying to make sure that the information that goes in is clean to begin with. And it's everywhere. I mean, it's in architecture, it's in art. Show me something where there's data and there isn't bias. So there's a huge sanitation process at the front end before you actually get out. And so, yes, I agree with the point that it's not necessarily the algorithm that's causing the bias. It's the data up front, and I think that's where the challenge lies. Tim, am I wrong?
No, I agree with you. And I think it's also important to always think about, well, what type of AI are we talking about? So if I'm talking about an orchestration technology that I'm going to use in order to shortcut programming in order to say, well, currently my payroll clerk, looks at the timesheet, calculates it, does this, does that, and eventually the person gets the check. If I can have a bot do that process so that once this step is done, it goes to that person for approval, right? And what I've done is I'm using AI in order to create the code and the business processes in order to do that. The risk of bias isn't zero, but it's not really that much of an issue. Where it becomes more of an issue is in those is generative AI, where I'm asking the AI to produce a report or answer to something, and there Daniel's right, like garbage in, garbage out, but also hallucinations, and hallucinations can happen in a certain way when AI doesn't know what the AI is looking at. AI is generally probabilistic when it's doing that kind of generative AI task. And so it's thinking about, well, what word would come next? Well, and what should happen next in that sentence, or how that drawing should look. And that's where whatever it was trained on is the world is not a neutral place. The world is filled with discrimination and bias and other things. And so all of that would be ingested into it. So a lot of effort is spent by the developers of these models to try to tune the AI to prevent either to prevent that bias, or to at least to either in the data sets going in, or to prevent or counteract the bias in the probabilistic reasoning of the generative AI.
Thanks, Tim. Just trying to keep the ball rolling here, because there's a ton of questions, and I apologize if we don't get to your questions, but one that we sort of touched on in the presentation and that we might be able to expand on now, and Tim, you're free to opine on this one, but it's kind of geared towards Danielle. Would it be beneficial for organizations in Canada outside of Quebec to align with Law 25?
Yes, for everybody else's sake. Unrealistic from a constitutional perspective. Law 25, yes, is stricter, but we're seeing Alberta, British Columbia also with legislation that's maybe not as demanding, but it's up there, especially with respect to what it regulates and how it regulates it. I think what is interesting, and I love the question, because when we first enacted PIPEDA, we chose an ombudsman model for many reasons, but one of the reasons I've always heard is that, oh, well, if we force businesses to do too much, they're not going to want to come to Canada, they're not going to want to comply, it's going to be tough on business. Now it's almost the opposite. Business wonders what's wrong with you if you don't have this legislation, because California's required it, and the U.S. is, or the EU has required it, and many Asian countries, the big players have certainly required it. So if you don't, it's almost as if you don't have the legislation, you're blacklisted, as opposed to when this all started. So I think it's not. I also think just as many, I guess, things are used to market social responsibility on the part of an organization, being compliant, being respectful of the way that you use your client's information is probably a really good marketing tool. I want to do business with a company that I know is going to protect my information and going to protect it to a standard that I understand and respect.
Thank you, Danielle. Okay, so we're out of time for questions, and there's only a few moments remaining in the webinar. At this stage, we just wanted to give a quick shout out to Danielle and Tim's books on privacy law. You see them on the screen. We'll include links to those and a recording of this webinar in our post-webinar email. We also wanted to just highlight that LexisNexis recently launched its AI Assistant Protege. There'll be a poll question on that. If you'd like to see a demo, select yes, and one of our folks will reach out to you. And finally, a special thank you to our panelists. You are excellent, and thanks to everyone for joining us today. We hope you leave with at least some greater clarity on AI regulation in Canada. Bye for now.
Thank you very much.
Thank you.